सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Before we begin, I'd like to have a short summary, a brief summary of Subhashree ma'am. Subhashree ma'am is a fellow chartered accountant and an alumna of prestigious Indian Institute of Management, Kozhikode. She is also a certified associate of the Indian Institute of Bankers with over 7 years of rich experience in central banking at Reserve Bank of India. During her tenure at the RBI, she contributed significantly across departments, including the Office of the RBI Ombudsman, Department of Supervision and Issue Department and Human Resource Management. Subhashree is not only a dedicated professional, but also a passionate speaker and motivator, having delivered sessions to college, institutes and students. Thank you, ma'am, for accepting our invite today. Before I like, C.A. Ramesh said to deliver the memento to the speaker. Thank you. Thank you, sir. We look forward to have an insightful and engaging session, ma'am.
Good evening, everyone. I'm glad you all made it to this evening on a Monday afternoon. Thank you so much. I hope the session will be very insightful and informative for everyone over here. And I'll start with a small disclaimer. So I was attached with RBI till 2023. I no longer work for RBI. So I'm an ex-RBI personnel. So all the objective points that I discussed during the discussion are points from the scheme, and all subjective points that I discuss are my personal points and not the official stance of RBI. And what is the purpose in me delivering this session is to ensure that everybody who goes through this session at the end of the session will have as much clarity on the scheme as I have on this topic. What is the scope of this session going to be? Purely the Reserve Bank Integrated Ombudsman Scheme is going to be the scope. We will not venture beyond that. We may quickly touch and go any relevant provisions outside the scheme, but only to the extent it is important to understand the scheme, we will be touching those points. And I also do not put a lot of information on my slides, but after the session, if one revisits the slides, I'm sure you'll be able to recall what was discussed in the session, and you'll be able to recall it to the extent useful for you to use this scheme. And regarding the speed, if I'm very fast at any point in time during the session, please feel free to stop me and ask me to slow down. I will slow it down. And if you want me to repeat anything that I have just said, please do ask by interrupting. I'll also repeat the same point. I'll try to paraphrase it and ensure that everybody understands it again. And as we move from one slide to another, please feel free to stop and ask questions regarding what we have just discussed in this slide. If you are not very comfortable interrupting, we can always discuss at the end of the session also. Either way, it's fine with me. So let me start the session. So what is this Reserve Bank Integrated Ombudsman Scheme about? So Reserve Bank felt it was important to ensure consumer confidence in the banking system of the country that we have a consumer grievance redressal forum at the RBI level. So what happens when a banking consumer has an issue? He goes to the bank with a complaint. If it is not resolved, then the only forum that was left, or the immediate top of the mind next forum prior to the introduction of the banking ombudsman scheme in 1995 used to be courts, and it used to not be the most sought after forum. Most people will not go for a resolution to court thinking of the cost, thinking of the time involved. So it was felt it is important to have an alternate grievance redressal mechanism at the level of RBI. So what are the services that are going to be covered in this? So this is only in relation to services provided by regulated entities of RBI. So RBI has to be the regulator of these entities, and within that there is a subset for which the new scheme of 2021 is applicable. Not every regulated entity is still covered, but it is only a matter of time. Over a period of time, eventually all entities will be covered. It moved on to non-banking financial companies in 2018. Then digital transactions started getting covered in 2019. And the most recent addition has been the credit information companies. RBI seek to provide through this mechanism a very cost-effective and expeditious resolution mechanism. Why it is cost-effective? Because it is absolutely free from RBI's side. RBI does not charge any money for this. Although sometimes if a professional help is sought to file the complaint, the person may end up paying some fees to the professional. Again, it will not be an advocate, and we'll discuss why it is not an advocate later. And how does RBI get the power to bring this scheme into effect? It has got powers under different acts. One would be the Banking Regulation Act 1949, which section it would be 35A, and it would be 45L of the Reserve Bank of India Act that pertains to NBFCs. And then we have the section 18 of Payment and Settlement Systems Act 2007, and that would cover all the payment system participants who are covered under the scheme. And then we also have, for credit information companies, section 11 of Credit Information Companies Regulation Act 2005. So what are these different sections pertaining to? In a broad sense, all these sections are the sections that give the power to RBI to give directions to these entities. What are these directions meant for? In a way to influence the banking policy or the credit system of the country such that it is not going against the economy, it's not going against public interest. So anything in public interest or anything to ensure that the credit system of the country is functioning properly, the payment system of the country is functioning properly, such that the credit information business is not functioning in a manner detrimental to the interests of its users. So to ensure that all these systems are functioning properly and the users are not affected unduly due to certain procedural aspects or due to certain views taken by the business related views taken by these entities, RBI has exercised these powers under various acts and brought under the ambit of this scheme all these entities. So when did this particular scheme of 2021 come into effect? It was in the middle of the year. It was November 12, 2021. So anything prior to that, if it was a bank, it would be Banking Ombudsman Scheme 2006. But of course, after 2006, it was amended many times. But the main scheme was Banking Ombudsman Scheme 2006. And the NBFCs, as I said, were covered under 2018 scheme. And digital transactions, when I say digital transactions, net banking of banks will not be covered under that. That comes under Banking Ombudsman Scheme itself. When I say digital transactions, I mean wallet transactions, prepaid instrument transactions. Those were brought into the ambit through Digital Ombudsman Scheme in 2019. So this particular scheme, as I said, comes into effect on November 12, 2021, and in a subsequent amendment in 2022, credit information companies were also included. So what is the geographical extent of coverage? The geographical extent of coverage is whole of India. Although RBI offices may not be there in every union territory, and main offices may not be there in some states. Some states will have only sub-offices. Despite that, it covers the whole of India. Even though there is no office, for example, say in Andaman Nicobar Islands and Lakshadweep, even they are pretty much covered. So anybody from anywhere in India can raise a complaint relating to a service that they have received within India from a regulated entity of RBI. So what are the services that will be covered? I said services provided by regulated entities, but services may be provided by the regulated entities under different acts, sometimes not even under the regulatory purview of RBI. For example, banks may provide you ASBA account services, but ASBA account services do not come under the regulatory purview of RBI. It would come under the regulatory purview of SEBI. So if you have a problem with ASBA account services from your bank, can you come to Ombudsman in RBI? No, because it is not a service under the regulatory purview of RBI. For those services, you cannot come. So if some banks are providing, say, asset management services under their own, under their own company without having a separate subsidiary. So even then, although it is a bank, although regulated by RBI, asset management services will not come under RBI's purview. So again, those services, yes, ma'am, no problem. Again, complaints related to those services will not lie before the Ombudsman. So it will be made non-maintainable if such services complaints are filed. So amongst the banks, are all banks covered? Is every entity which is named a bank covered? Most of it, but not all of it. I'll just mention the list. So it's the commercial banks, regional rural banks, scheduled primary urban cooperative banks, non-scheduled primary urban cooperative banks with deposit size of 50 crore or above. So non-scheduled primary urban cooperative banks alone have an asset size criteria. All the other banks that I mentioned are fully covered. And any banks that I have not mentioned, for example, I have not mentioned state cooperative banks. So scheduled and unscheduled state cooperative banks are not covered. District central cooperative banks are not covered. Local area banks are covered. Coming to non-banking financial companies. Non-banking financial companies, either they are authorized to accept deposits. So if they are authorized to accept deposits, they are covered irrespective of whether they are having deposits or not at this point in time. If they are authorized to accept, they are covered. And if they have a customer interface with asset size of more than 100 crore rupees. So they have to have a customer interface and an asset size of more than 100 crore rupees as on the audited balance sheet date of the previous financial year. Audited balance sheet date of the previous financial year. So even ARCs come under this ambit because of this particular clause. So they have a customer interface and they will have 100, if ARC is having more than 100 crore assets on a particular balance sheet date, they also get covered. And subsequent to that, we have system participants. Now, system participants are referring to payment system participants. Generally, if you go to the Payment and Settlement Systems Act 2007, the system participants includes the system provider. But for the purpose of this scheme, system provider is not included. So, system participant other than RBI and system provider is system participant for the purpose of this scheme. And credit information companies, all 4 credit information companies which are operational right now are included under this scheme. So if you have any issues with regard to, say, you don't have any issues with your bank, but you have issues with the way it has been recorded in your credit history and the bank is saying that they have provided the correct information, so the mistake probably lies with the credit information company. So you can, without involving your bank, file a complaint against the credit information company, which is showing a faulty record. The scheme also provides for provisions of suspension. This suspension is something that is there in the scheme always but never used. So what is this provision saying? It says that if RBI finds it expedient to do so, it may suspend the scheme, either partially, certain specific clauses, or fully for such period as it may deem fit. And it could be in general or in relation to any specific entity. Although the scheme is there since 1995, neither I nor anybody I have spoken to is aware of a period where this particular provision was used. And such suspension, once notified, can be extended from time to time as deemed fit by RBI. Now let's slowly go through definitions under the scheme one by one. We'll be going through mostly in alphabetical order. So appellate authority, previously the appellate authority used to be the deputy governor who is in charge of the Consumer Education and Protection Department of RBI. But with the new scheme, it has been decided to make the executive director in charge as the appellate authority for the scheme. So appellate authority would be the executive director, and appellate authority secretariat would be the department in RBI which is administering the scheme, that is Consumer Education and Protection Department. So if you look at the structure, so you have the governor, then you have the deputy governor, and deputy governors will have separate portfolios. One of these deputy governors right now, Mr. J. Swaminathan, has this portfolio of Consumer Education Protection Department. And under him, there would be an executive director. They will also have a portfolio of departments. So one particular person will have the portfolio of Consumer Education and Protection Department. Under him, there will be all the ombudsman offices. Right now, we have 24 ombudsman offices across the country, located in 20 offices. Why 20? Because 4 places have 2 ombudsmen each. And so the next definition that we will be going through is authorized representative. I'm sorry, I've missed it here. So authorized representative would mean a person other than an advocate. Actually, there was a court case also on this. Advocates felt that they should also get the right to represent before RBI, and they went to court asking that did they have a right to do it? How can RBI exclude them from representing ombudsman before the ombudsman? So it was held, it was a Madras High Court ruling, it was held that it's not an absolute right, and since ombudsman proceedings are quasi-judicial in nature and summary in nature, RBI has the power to exclude any person from representing a complainant. So an advocate can file the complaint if he himself is the aggrieved party, but he cannot file a complaint for somebody else. Only advocates are the only professionals who are excluded under this scheme. So the authorized representative should be duly appointed and authorized in writing. So oral authorization will not do. Whether this is strictly followed, in some cases there have been instances where the ombudsman has taken a benevolent view, and sometimes just by including the authorized representatives' names, or just somebody saying that they are filing on behalf of their senior citizen parent, there have been a few cases where it has been taken up. But as the implementation gets stricter and stricter, in the initial stages that was done, but as it gets stricter and stricter, it is important that the authorization is available in writing to represent a complainant in the proceedings before the ombudsman. And what is an award? Award is passed by the ombudsman in accordance with the scheme is the definition. I'll explain it a little more. So award comes at a point where we are not able to arrive at a solution. So we have considered the information presented by both the parties, but we are not able to arrive at a solution. So, or the 2 parties are not coming to a common ground. So the ombudsman passes an award stating the action points for either of the party or both of the parties. So that is an award. An award, once given, has to be disclosed in the annual report of the regulated entities. So generally, it is not seen as a positive thing in the annual report of the regulated entities. Bank, as per the scheme, would mean a banking company, a corresponding new bank, which means a nationalized bank, a regional rural bank, State Bank of India, as defined in Banking Regulation Act 1949, a cooperative bank as defined in Section 56C of Banking Regulation Act 1949, to the extent not excluded under the scheme. As I said, non-scheduled primary urban cooperative banks with deposit size of less than 50 crore will not be included. However, despite the inclusions, if a bank becomes a bank in resolution or winding up or under directions, or any other bank which is specifically mentioned to be excluded, that will not be covered under the scheme for such period as these conditions hold valid. So if it's in winding up or you will of late see many times cooperative banks are placed under directions by RBI. So that directions may be for a certain period of time, they keep extending for 6 months at a time. So those banks will not be covered under the scheme for that period when it is under directions. Even if it's under voluntary winding up, it will not be covered. So what's a complaint? A complaint would be a representation in writing or through other modes. When we mean or through other modes, those are also written modes only. It just means electronic modes. Alleging deficiency in service on the part of a regulated entity and seeking relief under the scheme. So every part of this definition has to be fulfilled for communication from a member of the public to qualify as complaint. Credit Information Company would be a company as defined in the Companies Act 2013 and which has been granted certificate of registration under Section 5(2) of Credit Information Companies Regulation Act 2005. Deficiency in service would be any shortcoming or inadequacy in any financial service or such other services related thereto, which the regulated entity is required to statutorily provide or otherwise, which may or may not result in financial loss or damage to the customer. So, why would a complaint come if there is no financial loss or damage to the customer? The only answer remains to be inconvenience. If it has caused harassment or inconvenience, that shall also qualify, although there may not be a single rupee lost. A deputy ombudsman is a person who is appointed as a deputy ombudsman under the scheme, just as much the same definition for an ombudsman. A person appointed as ombudsman would be an ombudsman under the scheme. Non-banking financial company would be as defined under Section 45(I)(f) of the Reserve Bank of India Act 1934. To the extent not excluded under the scheme, what are the exclusions? A core investment company is not included. Infrastructure debt fund company, non-banking financial company is not included. Non-banking financial company, infrastructure finance company is not included. Also, NBFCs which are in resolution, winding up or liquidation or under directions of RBI and any other NBFC specified by RBI would be excluded. Regulated entity would mean a bank, an NBFC or a system participant or a credit information company as defined in the scheme, or any other entity as may be specified by the bank from time to time to the extent not excluded under the scheme. So apart from this, is there any entity that features in the list of regulated entities? I found one on the CMS website. The CMS website basically gives you a list of entities that are covered under the scheme and list of entities that are also not covered under the scheme. So in that, the list of entities that are covered under the scheme, there is one state scheduled cooperative bank which I found. The Karnataka State Scheduled Cooperative Bank I found. So although I could not find any notification relating to it on the website or any news article related to that, that particular entity features in that list. So this could probably be a case where it's specifically mentioned and therefore it is covered, although the rest of the category does not seem to be covered. So what is a settlement with regard to the scheme? It means an agreement reached by the parties, so it will be the regulated entity and the complainant, by facilitation or conciliation or mediation as per the provisions of the scheme. So what is a case of facilitation? So say a complainant has filed a complaint and then the bank is asked to reply. The bank goes through the complaint and the person who's administering this consumer grievance redressal mechanism in the bank feels, okay, this person has a valid grievance, the branch has probably not handled it properly, let's redress it. And they have solved the problem. So the complaint came to RBI, the complaint was sent to the bank asking for their reply, they have solved the issue and they are coming back to us. That would be a facilitation. Even if there is a couple of times back and forth between RBI and bank, and without having to bring both the parties to the table, through the negotiation table, if it is done and if it is solved in favor of the complainant, it would be a resolution by facilitation. So generally, although there are other clauses which we will shortly discuss, generally, if the complaint is solved in the favor of the complainant, it tends to be a resolution by facilitation. Generally, if it is in favor of the bank, it would be a clause which says there was no deficiency in service. Moving on. So system participant, as I said, normally, or rather under Payment and Settlement Systems Act, system participant includes a service provider, but under the scheme, it does not include. So the definition goes by these words: a person other than the Reserve Bank of India and a system provider participating in a payment system as defined in the Payment and Settlement Systems Act 2007. So system provider is a person who operates an authorized payment system as defined in Section 2 of Payment and Settlement Systems Act 2007. Reserve Bank is Reserve Bank of India, constituted under Section 3 of Reserve Bank of India Act 1934. To the extent definitions have not been, these are the definitions that have been provided. To the extent definitions are not provided under this scheme, so where do we refer to? We have all these acts under which, and in the exercise of powers under which RBI has brought the scheme. If you can find a terminology featuring in the scheme, not defined here, but featuring as a definition in those acts, we can use the definition from those acts. If it's not available in these acts, but it is available, say, in a guideline or a regulation or a rule or a direction which is issued under these acts. I'll just list down these acts once again. So it will be Reserve Bank of India Act 1934, the Banking Regulation Act 1949, Payment and Settlement Systems Act 2007, and Credit Information Companies Regulation Act 2005. So if it's not there in the scheme, the definition could be in any of these acts. If it's not in these acts, any regulation, rule, direction or guideline issued by RBI under any of these acts, if the terminology used in the scheme has a definition there, that can be used and applied. So RBI is free to appoint as many ombudsmen and as many deputy ombudsmen as it feels necessary for effective and efficient functioning of the scheme. So ombudsman, as I said, 4 metros have 2 ombudsmen each. Apart from that, we have 20 other offices which have totally 20 offices have 24 ombudsmen. So apart from that, you have 16 offices with 1 ombudsman. Every ombudsman will have minimum 1 deputy ombudsman. Because under this new scheme, powers have been devolved to some extent to deputy ombudsman also. Earlier, every complaint had to be closed by someone who is at the ombudsman level. But under the new scheme, some complaints can be closed by people at the deputy ombudsman level, and only some complaints have to compulsorily go till the level of ombudsman. However, if a particular complaint or a clause allows for closure by a deputy ombudsman, but the ombudsman feels that this complaint, it is better to send it to the ombudsman once to know their opinion and make them close it. Can it be done? Very much. Anything that can be, any complaint that can be closed by a deputy ombudsman can definitely be closed by an ombudsman also. So if the deputy ombudsman wants to escalate the complaint to ombudsman level because they feel the case is complex or for whatever reason, it can be done. And the appointment, the tenure is not to be more than 3 years at a time. The same person can be appointed again after a break. But it's not necessarily 3 years also. It can be less than that, but maximum 3 years at a time. This holds good for both the deputy ombudsman and the ombudsman at every office. As far as location of the office of the ombudsman, again, this could be the cost factor, the administrative convenience factor, and the volume of complaints, the region from where maximum complaints come. All these would contribute to the factor in choosing a location for holding an additional ombudsman office or a new ombudsman office. Apart from the proper offices of RBI, is it possible to have a location of an office of ombudsman elsewhere? Yes. The scheme provides for it, but I am not aware of many instances or even a few instances where this has been done. It could have been done maybe long time back. Right now, in the recent past, I have not come across such instances. So the ombudsman may hold sittings at such places and in such manner as may be considered necessary and proper in respect of a complainant. Let's say a person is, I'm just giving a hypothetical scenario. Let's say a person is immobilized and the only way to reach the person is to probably be at his home. if the ombudsman decides to have a sitting at the places at the home of the person, adjudication, that can be done well within the scheme, and that will have the same effect as an order passed inside the office of RBI. This is a hypothetical situation. It's not that it has happened. This is establishment of a centralized receipt and processing center is again something new that has come under the 2021 scheme. So it was decided again for efficiency's sake, all the entry of complaints can be done by a particular group or a particular team, and that team will ensure that complaints received through multiple modes are forming part of the system. So we have digitized in RBI, the system, the complaint management system is absolutely digitized. And what happens is, say if you are filing the complaint through the online portal, what you are doing through the online portal is nothing but a user interface for the public for the same system that is part of RBI's staff complaint management system. So once a complaint is registered by, say, a member of the public in the online portal, it automatically reflects inside the RBI system. It is the same system. This is just the public interface. So that will be automatic. And then there is an email ID that is provided through which complaints can be filed. So every email that goes to this email ID will be filed as a complaint. And as per the procedure right now, anything that goes as an email, the people who are manning that email do not have the discretion to choose to not register. So if it goes as an email to that, it will be registered. If it is something that does not constitute a complaint, it will be registered and then closed, stating that it is not a complaint. So if it goes to that mail, it will eventually feature in the system and it will be registered as a complaint, and then whatever due process has to be followed will be followed. And apart from that, physical form. So these will include postal and hand delivered complaints. It is required and preferred that it goes to the centralized receipt and processing center in Chandigarh. Again, I will give you the address also shortly. However, we also have instances where these letters arrive at the respective ombudsman offices. Again, because the previous scheme required the letters to be coming to the respective ombudsman offices, it has become a practice for somebody who has already used the system to send it to the local ombudsman office. If it comes there also, it will be eventually put into the portal. It's not that it will not be taken into consideration, but there will be some delay because that has to go to the CRPC team. I will use this abbreviation. So it has to go to the CRPC team for entry into the portal. And in places like Chennai, it's still easier because we have some staff in Chennai office who are working for CRPC, Chandigarh. So if it reaches Chennai office, these staff will pick up these hand-delivered complaints and then register it after informing the person sitting at CRPC Chandigarh. However, if it goes to, say, a center where there is no staff of CRPC sitting there, then it has to be sent to another center. The hand-delivered complaint has to be sent to another center, and then it will have to be registered online. So in that case, it is better to send it directly to Chandigarh so that once it reaches Chandigarh, it will be given to staff who has lesser number of complaints at hand to register, and the quickest possible registration can happen. Say, for example, there are more physical complaints coming in Chennai office and you have also sent a complaint to Chennai office. By the time this person registers, it can be 3-4 days extra. Whereas if it goes to Chandigarh office, the moment it goes to Chandigarh office, they will have a tab which shows how many complaints are pending for registration with each staff attached to them across the country. They will scan it and send it to the person who has the least number of complaints, and the quickest possible registration for that complaint, physical complaint, can happen. So staffing of the offices of Ombudsman and Centralized Receipt and Processing Center, as I gave a hint of, is decentralized to a great extent now. It's possible that, say, a person sitting in Chennai is working for Bhubaneswar office ombudsman. It is possible for a person sitting in Trivandrum to be working for Karnataka ombudsman. So that way, Why it has been done? To rationalize the number of complaints. Historically, the metros have received humongous number of complaints, much larger than the complaints received by non-metro cities. So it was felt that let's rationalize it. So what happens, that is also one of the reasons why we had to digitalize it. So once the system captures the complaint, it will try to go to the default ombudsman office. Say for example, it's a Maharashtra complaint within, again Maharashtra is split into two regions. Let's assume it is for BO1, Banking Ombudsman 1 of Mumbai. So if it's by default coming from the region of BO1, the portal will try to allot there, but the complaints volume in that particular office, if it's very huge and BO2 had lesser number of complaints, it will go to BO2. Or if say Kochi had very less number of, Kochi does not have a BO office, so let's say Trivandrum had very less number of complaints, it can be allotted to Trivandrum also. Again, this is efficient allocation so that anybody sitting anywhere can be handling your complaint. So you might have filed a complaint in Chennai, somebody might be calling you from Guwahati, saying, I'm calling from Ombudsman office Guwahati, I am dealing with your complaint. What I wanted some more information, may I send you an email? It is a legit call, it's not a fake call. So it's possible under the new circumstances. However, one exception, that is also not a strict exception, but one exception could be when you're writing in a regional language. Say if you have sent it in Tamil language and it has landed in Chandigarh's ombudsman office. So there, say nobody knows Tamil. So that will be shifted to Chennai office. Let's say I was posted in Chandigarh office and I happen to get that complaint allotted to me. I know Tamil. So I can process it. And if my deputy ombudsman can be convinced of my fluency and proficiency in Tamil, it will be properly communicated to him or her, and they can also check with somebody else if they want. They can still process it. There is no bar on processing a language outside the region, but mostly due to staff proficiency levels, it may go to the region to which it is to be allotted. So sometimes there may be a little bit of delay in such cases when it is going through online. So when you're giving a regional language complaint, it makes better sense to send it as an email, because email or physical delivery, so that it will go to the correct office straight away. Otherwise, in a random allocation, it's possible it may land in Karnataka's basket of complaints, and the dealing official, if it's not superficially visible that in which language it is written, only when you go to the details of the language it is visible, then the person will have to transfer it. It will take some more time to solve the complaint. So that is one point. Coming to the powers and functions of the ombudsman. So regarding the powers, so what are the types of complaints the ombudsman or the deputy ombudsman shall adjudicate under the scheme? As I said, it would be complaints relating to deficiency in service. If there is no deficiency in service, there will be no complaint lying before the ombudsman. At any point in time during the processing of complaint, if it is discovered that there is no deficiency in service on the part of the regulated entity, it will be closed as such. It's possible prima facie it looked like there was a fault at the bank, so they were asking you for more details, they were asking the bank for more details. Just because they asked you for more details, it cannot be claimed that how can there be a deficiency on the bank side because you already corresponded with me asking for more details. It cannot be claimed. So at any point in time it is discovered, it is decided that there was no deficiency, the complaint will be rejected under a clause pertaining to that. Regarding the limit on the amount of dispute that can be taken to the ombudsman offices, there is no limit. So it can be a 5 crore dispute, it can be a 200 crore dispute, there is no limit. The disputed amount has no limit, it can be taken to the ombudsman office. What has a limit is the consequential loss. If you are asking compensation for consequential loss, there is a limit of 20 lakhs. And if you're asking compensation for harassment, mental anguish, and expenses incurred, that has a limit of 1 lakh. So disputed amount can be anything, but if you're seeking a compensation, it's possible you had a consequential loss of 30 lakhs, but you're seeking a compensation of only 20 lakhs, you can still come to Ombudsman. But if you have a consequential loss of 20 lakhs and you are asking, say, 20 lakhs consequential loss, but 3 lakhs for mental harassment and mental anguish, you will not get your complaint processed under this, because you're asking for more than the limit given to the ombudsman and the deputy ombudsman. So deputy ombudsman has power to close complaints which are non-maintainable. We will shortly discuss what are the non-maintainable complaints. These are complaints mostly which will come under clauses saying that without going to the bank, you have straight away come to the RBI ombudsman office. So complaints like that which are to be rejected, that can be done at the deputy ombudsman level. And out of complaints which are not rejected but can be still closed at deputy ombudsman level, it will be a complaint that is resolved by facilitation. Facilitation, as I had mentioned, it's something that is sorted out without having a need to bring both the parties to a negotiating table. So there, the deputy ombudsman, especially say if the complainant has given a letter saying that the bank has resolved my complaint as of now and I'm satisfied with the resolution provided. Thank you for your help and all. So if a complainant is giving a letter like that and the bank produces that letter and the deputy ombudsman has confirmation from the complainant side also, or even otherwise it is believable that he has given this and the bank has done the necessary resolution, there the deputy ombudsman herself or himself can close the complaint. It doesn't have to go to the ombudsman level. So every ombudsman office has to report annually to the deputy governor with a general review of activities carried out till the previous financial year, that is as of every March 31. And any other data or information that is being called for in a particular annual report will also have to be furnished by the ombudsman office. And is this published to the public also? In the public interest, actually, RBI has been publishing a separate annual report for banking ombudsman offices. So, Consumer Education Protection Department has published every year an annual report separately for banking ombudsman, stating how many complaints were resolved. It doesn't give office-wise breakup. Again, that power lies with RBI to choose to give it in a consolidated form or office-wise breakup. So, it is available. In right now we have only 2023 and 2024 which is available, and that was released in January 2025 only. If you want to take a look, you can always take a look at it. And the complaints have only been steadily increasing. The cost has been coming down. Just to give a ballpark, in 2023-24, the cost per complaint resolution, cost for resolving one particular complaint has fallen from around 2,400 rupees per complaint to 1,700 rupees per complaint. The total cost, if you look at it, actually comes to 49 crores. So that is the amount of budgetary allocation this department has to ensure that people's grievances are resolved without having to go to other forum. Let's spend some time on this particular slide. So, every word of this particular clause is very important. Any customer, so there has to be a customer relationship. Any other relationship will not do. So, for example, say you are holding debentures of a bank and that was sold to you by the bank manager only. And you have invested in it and you have not got interest for a particular time. So, particular time period. So, can you go? When you're holding debentures, you're not a customer of the bank. You are somebody who has given credit to the bank. You're a creditor of the bank. Similarly, say you have not got dividend. You are a shareholder of the bank. You're not a customer of the bank. So, any deficiencies in a relationship, in the service of where the relationship is not a customer or regulated entity relationship, there you cannot have a ground for filing a complaint under this particular scheme. So there has to be a grievance It should not be in the nature of the problem was solved, but it could have been done better. No, that cannot be a grievance. So there has to be a grievance where something was done or something was not done, and because of which you have a sustaining problem. So you should have an active grievance. It should be due to an act or an omission of a regulated entity. Here, regulated entity will be only that subset which is covered under the scheme, although the actual regulated entities is much more for RBI. There has to be a deficiency in service. If there was no deficiency in service, as I pointed out many times during this session, the complaint shall not lie. So, the complaint can be filed personally or through an authorized representative. Authorized representative should be a representative authorized in writing. Okay. So as we proceed to the processing of complaints under the scheme, let's first look at what complaints are non-maintainable under the scheme. It's required if you have a grievance. Yes, ma'am. Yes. So if, like, for example, first point of contact. Sorry? Yes. First point of contact over here would be the bank. So I'll tell you how step by step it has to be done. Let's assume I'm having the problem. So I go to my bank saying that I had closed my credit card with you long back. I had settled all the dues, but it is still featuring as if I have not paid, some amount is still due. And you have to close it in my credit information report. The bank, if it resolves, fine. So for how do I go to the bank? I have to go in writing. So either I file a complaint through the bank's website, or so I have an acknowledgement number, or I file through, say, telephone where I've got an acknowledgement number, or I file it in writing. I've sent it to the branch with an acknowledgement due, so I have proof it has been delivered, or I go in person and take an acknowledgement in a second copy. So I've given one part of the complaint, one copy of the complaint, in another copy I've taken acknowledgement from the branch that for this particular complaint I have given it to you. So the bank has 30 days to resolve it. The bank, assuming, does not resolve it, or tells me we have already sent it correctly, they have only not done. So can I file a complaint against the bank? You can, because your problem is not solved. Unless you are very clear that the bank is not at fault, it is better to file the complaint against your bank rather than against the respective credit information company. Also, if you have multiple credit information reports and it is featuring in all the reports like that, the probable person who is at fault is the bank or the NBFC. So then you can file the complaint against the bank. Also mention very clearly in your complaint in which reports, in the reports of which companies this is featuring and to what extent it is wrong. The more specific you are, the better your resolution will be, because exactly what relief you seek, you will get, if justice is on your side and if truth is on your side. So, yes, so we gave 30 days to the bank, they did not resolve it. So then we go to RBI. RBI, I can go online or through email. Online in the sense online portal, or through email, or again a physical complaint. Either way I can go. And I have to specifically state that I am applying under the Ombudsman scheme. That is also one of the reasons sometimes people's complaint may get rejected. They may not specifically address it as, going under the Ombudsman scheme. They will put everybody in the, recipient email address. They'll put everybody all the way from finance minister. So then it is not directly addressed to the Ombudsman, that will get rejected. So specifically under the Ombudsman scheme, I'm saying this particular bank has done this to me and it is wrongly featuring in these many credit information reports of these companies. This is the mistake. This is how it should be. If I specifically state this, what will happen? Let's assume I have done it on the portal. The moment I register it on the portal, there is one problem with the portal. You can identify only one regulated entity. So let's say it's ABC Bank. So ABC Bank will get a copy of my complaint the moment it's lodged on the portal. The manual dealing official, the person who's dealing with my complaint, who's been assigned my complaint, will have to manually allot it to the credit information companies, the ones I have mentioned in my complaint. So that will also take some time, but few days only, not much. So the bank has 15 days time to reply. Each of these credit information companies will also have 15 days time to reply from the time they have got the complaint. So depending on what replies we get, the dealing official will be able to identify where the problem is, and whosoever is the person who's causing the problem will be told to rectify it. So there is no timeline for resolution of complaints, but it will eventually be done. You can rest assured. Very recently, we have done it for a family member. So what happened was, the person had a loan, and that loan was closed, and it was still featuring as an open loan. So we went to the the bank which did the mistake. The bank did not resolve it. We went to the Ombudsman office. The Ombudsman office first came with a reply saying that the bank has said they will do it in so many days. We insisted, no, we want it done. We'll wait for the complaint to close. If it's not too much of a time to wait for, the bank will keep the complaint open, and then they will ensure that your report is duly rectified. They will give you the report. Once you say go ahead, you can close the complaint, they'll close. However, sometimes if the credit information company has a valid cause saying it will take some, say, 30-40 days, the bank may think it more effective or expedient to close the complaint for now, but it will give you a reply saying, if in 45 days they have not done as they have said, feel free to file a complaint again, we will entertain it. Normally, if a complaint has been settled, it is not allowed to be entertained again. But where you have a closure letter which states this, if it is not, the regulated entity has given time to asked for time till 15 days. After that, it will be resolved. If it's not resolved, you may come to us. If your closure letter is stating this, you can go for the same cause of action again before an ombudsman. In the absence of this, you cannot go for the same cause of action. Yeah. Yes. Yeah. I'll just have a sip of water. So we'll go through the grounds for non-maintainability of a complaint. We can use the example that we just discussed throughout the course of the session, I guess. So let's say my credit card was not closed, and without going to the company issuing the credit card, I have directly gone to Banking Ombudsman saying it was closed 6 months back, but it's still lying open in my credit information report. The bank will make the complaint, Reserve Bank will make the complaint as non-maintainable, saying you have not raised the grievance before the entity first. So a first resort complaint is a non-maintainable complaint. So you have to first go to the entity with whom you have the grievance, 30 days time for the entity to reply to you. If the reply comes within 15 days also, but you're not satisfied with the reply, you can come. If the reply is not coming, you have to wait till 30 days. So let's say the reply comes after 45 days. And after that also, if you're not satisfied, you can file. Let's say after 45 days, the reply you have already filed with Reserve Bank of India. After 45 days, you have got a favorable reply. You can withdraw your complaint that you have filed under the scheme. So these are all the possibilities. Delayed complaint. So as much as there is a minimum time required to be given to the bank to solve the complaint, there is a maximum time within which you have to file the complaint before the Ombudsman office in RBI. So let's say I have filed a complaint, the same complaint. My credit card was closed, but still featuring in credit information report. Bank has not replied for 30 days. From the date of my complaint, 1 year and 30 days is my time limit. So let's say I gave it on 31st November. I have to file my complaint before Banking Ombudsman before 30th December of the next year. So 30 days, up till 30th December, I've given time to bank. I have not got a reply. I should go to RBI before 30th December of the next year. So 1 year and 30 days where there is no reply. If there is a reply, 1 year from the date of the reply. So is it possible to extend this beyond 1 year and 30 days? Is that the maximum? Not really. Say if the bank has given me a reply after 60 days and I did not pursue it before the ombudsman before that. So 60 days the bank has taken. From the date of the reply, I get 1 year. So my total time becomes actually 1 year and 2 months. Duplicate complaint. Now, duplicate complaint is a complaint, just a moment. Yeah, duplicate complaint is a complaint with respect to the same cause of action. Does not matter if the complainant name changes. Say, for example, this is regarding a loan that I and my husband have taken it, and then there is a problem with that. I filed a complaint. It has been settled in favor or not in favor. My husband, who's a co-borrower for the same loan, for the same deficiency, for the same transaction, cannot go to Banking Ombudsman because the same cause of action has been dealt with by an ombudsman already. So if it's pending before an ombudsman also, it is not to be done because it's already in process. So a complaint which is in respect of same cause of action, which is already pending before an ombudsman or settled or dealt with on merits by an ombudsman, whether or not received from same complainant or along with one or more complainants, a new name coming, like I have filed singly earlier, now jointly I'm filing along with my husband, no, same cause of action, so will not be taken up again. Let's say the complaint is not pending before any ombudsman and it has also not been dealt with by any ombudsman, but it is pending before a court. Even then, ombudsman will not take it. If it is pending before a court of law, ombudsman will not take it. A tribunal or an arbitrator or any other forum or authority, ombudsman will not take it. If it has been dealt with all these forums, court, tribunal, arbitrator, it will not be taken by ombudsman. So it should not be pending or dealt with by any ombudsman of RBI. It should not be pending or dealt with by any other forum. So there was a case that happened. A person had a case pending in a court for a transaction, a loan related transaction with a bank. We now have a contact center in RBI where you can call to ask details about the RBI Ombudsman scheme or about the status of your complaint which you have filed or for some guidance regarding how to file a complaint. The contact center number is 14448. So this particular contact center, we received a call asking that, my case is pending in court, it is taking a lot of time. So I would like to file a complaint. I did not know about the Reserve Bank Integrated Ombudsman scheme earlier. So, but now I am aware I want to file a complaint. Can I? The answer that was given to that person was, no, you cannot file a complaint because it's pending before a court of law. The person went and withdrew the case from the court of law and then filed the complaint. It was admitted in RBI Ombudsman scheme. So it's not pending. It has not been dealt with. It did not lead to a logical conclusion in the court. Before that, he is withdrawn. It is no longer pending as of the date of the complaint filed before Ombudsman. So it was admitted. So what he did, he exhausted this option and then again went to the court of law. So this is a possibility. Sometimes a complaint is received full of scoldings. We don't know what is the matter. We don't know what is the deficiency in service, what has happened and why the person is so agitated, why the person is so angry. It is only filled with only abusive and it simply says a particular regulated entity is good for nothing. It's just saying that. It doesn't mention what is the cause of action. That will also be rejected. So a complaint which is frivolous, vexatious or abusive will also be rejected as non-maintainable. The Limitation Act period of limitation is also relevant for filing a complaint under the scheme, but the limitation period should not be only when you go to the regulated entity. You can come after the expiry to RBI. So this is what the scheme states. The complaint to the regulated entity was made before the expiry of the period of limitation prescribed under the Limitation Act 1963 for such claims. So you should have gone to the regulated entity within the period of limitation, not wait for the expiry. By the time you come to RBI, if the expiry has happened, it's okay. So incomplete complaint. RBI has actually given along with the scheme a format in which complaint has to be filed for physical complaints. Of course, when you go through the portal, it will be in that format. So automatically you will file according to the required format. Sometimes what happens, people, again, this is also because of the previous schemes where you can file it in a free flow with some basic details. And such complaints are as of now entertained, but at any point in time, if RBI has, if they want to insist that it has to be in the specific format or a particular detail which is compulsory as per the format is not featuring in your complaint, can they reject it saying it is incomplete? Yes. If they are still entertaining, it is out of discretion. Complaint filed through advocate, because it's a quasi-judicial authority and RBI has chosen to keep it's also because of the proceedings. The proceedings are summary in nature. You don't go through elaborate documentary evidence or oral evidence. It's not like a court proceeding. So it's not, such complaints which require such a process are not suitable for RBI Ombudsman, and therefore representation has been restricted for advocates. So let's say I have missed my credit card payment. I have got a huge interest now to be paid in the next bill. This is the first time I have missed in, say, 4 years. And I have been very prompt in all other payments. I'm telling you, this is the first time I have missed. Ask for a waiver. I ask the bank which has issued me the credit card to reverse the bill. Reverse the interest portion in the bill. They refuse. I go to RBI. It's a commercial judgment. It's a commercial decision. Have I made a mistake? Yes. Is it a first time? Yes. But does first time prevent the bank from levying interest? No. As per the agreement I have with the bank, they are well within their right to put an interest, and they can choose to waive also. They can choose to waive for X and not waive for me also. It's all a commercial decision. So for this, if I go to RBI, bank chooses to not reverse, I will not get the resolution I seek because it's a commercial judgment or a decision. So this becomes a rejected complaint or a non-maintainable complaint. As I said, you have to be a customer to be filing complaint under the scheme. So if you're a vendor and your relationship with the regulated entity is also with regard to, say, an outsourcing contract, and you have a dispute with regard to that particular outsourcing contract, so a complaint cannot be filed before RBI. So somebody providing service to a bank, outsourcing service, has some issue regarding the payment, cannot come to RBI for the dispute, because there the relationship is a vendor to regulated entity relationship. The same vendor has a loan account with the bank. Something is going wrong with the loan account. Can he come? Yes. So the relationship that governs the cause of action that you are raising before RBI will matter. Was a customer means? Okay. And the dispute is okay. Outsourcing services, vendor, no. Only for services covered by the bank customer relationship. Yes. Complaint not directly addressed to Ombudsman. This is also a mistake a lot of, not a majority, a significant minority do. They will put everybody's email ID in the recipient list. Everybody like finance minister, RBI governor, SEBI, IRDA, everybody will be, RBI ombudsman, that CRPC email ID will also be there. So every email ID they will put. So that complaint gets rejected saying complaint not directly addressed to Ombudsman. You have to specifically make an address to the Ombudsman seeking a specific relief under the scheme. Can you have a lot of people in the CC and only the Ombudsman in the recipient list? Yes, that is a maintainable complaint. If you have everybody in the main list, that is not a maintainable complaint. So, any general complaint against the management and the executives of a regulated entity. Say basically, you have worked in a particular regulated entity and you find that the management is doing something which is fishy or which is not good, and then you want to report the unscrupulous behavior. Can you go and complain to RBI? Yes. Under this scheme? No. You have to complain to the Department of Supervision in RBI, not under this scheme. This, as I said, strictly governs customer bank or customer regulated entity relationship. So if you send a complaint under this scheme, it will be closed saying it is a general complaint or a general grievance against management or executives of a regulated entity. Will the complaint end there? No. It will be forwarded to Department of Supervision. You will get a reply saying this is a non-maintainable complaint under Ombudsman scheme, stating that this is the ground on which it has been closed. So you will not get further communication about it, but as part of a market intelligence input or as part of an information that has to reach the Department of Supervision, it will reach the necessary department. But I would suggest you may directly mail the respective department and not do it on this portal. This portal is not supposed to be handling volumes of complaints on this account. So when you have a grievance, I will also show you after this slides, after these slides, I will also show where to find these email addresses of RBI and how to complain. Complaint where it is not within regulatory purview of RBI. As I said, ASBA account provided by a regulated entity. Of course, if it's a separate entity which is not even regulated by RBI, if it's an insurance subsidiary of a bank which is not even regulated by an RBI, so that will also not be covered. And where for a dispute a remedy is already provided under Section 18 of the Credit Information Companies Regulation Act, again you cannot file a complaint under this particular scheme. So where a solution is provided there under that particular section, that so the section generally refers to having recourse to an arbitrator under the Arbitration and Conciliation Act. So if a remedy is being put in effect under that particular clause, or if it is found more suitable for that, then under this particular scheme the complaint will not be entertained. Say a regulated entity is having a customer account with another regulated entity. Even then, although there is a customer service provider relationship, they cannot come under this particular scheme if both are regulated entities. They have other fora within RBI to take up the issue, to take up the dispute. They are not supposed to come and populate this particular portal. Again, dispute involving employer-employee relationship, full and final settlement not received, bonus not received. So it's possible that you have an account in the same regulated entity that you worked for. You have left that entity and that entity has not credited your full and final settlement to your account which is with that entity. If the problem is HR department not releasing the amount, it cannot come under the scheme. If the problem is HR department has released the amount, the credit alone has not happened, then it can come under the scheme. So let's proceed to the procedure for filing a complaint. We will see it in detail in some time, but I would just draw your attention to the URL. So this is the URL where you can find the online portal in which you can file the complaint. We will shortly see a video on how to do it. So you can make note of this URL. You can also access this through the RBI website itself. Say if you go to the main RBI website and you navigate to complaints. Here for most regulated entities, you will find their respective emails to file the complaint. And then once that is done and you have not got a resolution under the Ombudsman scheme, this will again take you to the same page that I showed, the CMS website. It also gives the scheme document and respective addresses of the RBI Ombudsman would be here. This is the email ID to which, although it says grievance against any department of the Reserve Bank, that can also be sent here. But if you have an email complaint to be sent under the Ombudsman scheme, this is the email ID for that also. A physical complaint should be duly signed by the complainant or by the authorized representative. If the complaint is signed by the authorized representative, it should also have a document where the complainant has signed and authorized that particular representative to go for the complaint before RBI. So initial scrutiny, they will see if it is actually featuring as a complaint or not. Say if it is a suggestion, if it is seeking a guidance, an interpretation of a particular regulation or a direction. So all those are not complaints. Any seeking of information which should have been sought under RTI but has come under this, it will not be taken as a complaint. So any explanation that is being sought, that will not be treated as a complaint. They will all be closed, stating so that this is not in the nature of a complaint. So if you have other communication that has to be conveyed to RBI, as I said, you can find it through the RBI website. I'll quickly show that also. I should have shown it. So this is all the central office departments that RBI has. So if you want it to go to the central office department, you can choose the appropriate department and send it to them. Let's say, for example, you have found a FEMA violation of somebody. So this is the email ID to which you have to send. The Foreign Exchange Department. Say you have found something wrong with let's say a regulated entity's management and non-adherence to prudential reforms. So then this becomes the email ID to send that particular complaint. So you can find the central office department's email IDs in this particular page. If you want to approach this locally also you can do. Let's say I want to send the email only to Chennai office. Let's say it's regarding a cooperative bank. So here I will send it to Department of Supervision. So I'll have multiple emails over here. I can mark it to the Deputy General Manager in charge straight away, or I will mark it to the people who are the Deputy General Managers here. If I'm finding a violation, say in a cooperative bank in adherence to prudential regulations, this is the place I have to report it and not the CMS system. So complaints which are non-maintainable, which we already discussed, that will also be first rejected in the initial scrutiny itself. However, let's say they missed it in the initial scrutiny and subsequently it's discovered that it was a commercial decision or it was something that should have been, it was a first resort complaint. Initially it came, the person has given a particular date as saying that on this particular date I approached the bank. But the banks comes back saying that no, it was not approached, the person has not approached us and this person has not furnished any proof or any acknowledgement number for the complaint filed. Then it can be taken as a first resort complaint and closed even at a later stage. So let's say in the initial scrutiny of complaints, if the complaint is not rejected, so then the assignment to the offices of Ombudsman will happen, as I said, and further examination, and the intimation will keep going to the complainant either through email or through SMS saying that it has been assigned, your complaint has been registered, your complaint has been closed, provided you've given your mobile number and email ID. Any timeline for? No, there's no timeline for closure. Both, no timeline. So at any stage, if it's found it's to be rejected, it can be rejected. At any stage, if prima facie it appeared as if the customer was at fault, but due to further probing, it is so discovered that the bank was only at fault. The initial stand taken can change at any level and the final resolution can happen in any way. And the time taken, sorry? No, where it is already settled. Sorry? No, once dealt with or once pending, you cannot re-register for the same cause of action. Let's say you filed a complaint and it's still pending, it is still, when you are tracking the complaint, we will also shortly see how to track the complaint. When you're tracking the complaint, it is showing that, it is still pending, it is in process, or it is showing as it is with the bank. You have some more documents that you want to attach. Just ensure that your subject is the same. Refer to you would have already received a complaint number. Refer to that particular complaint of yours and file a complaint again in CMS. So additional documents can be sent, but this is risky. It would be better to do it at the first shot. It should not be that you are filing here, they have already passed. By the time you send it, the decision has already come. In that case, you have lost. So probably if you're doing it within say 1 or 2 days, you will not really lose an opportunity to file an additional document. But there is a risk here that it's possible that they may close by the time your document reaches, because you have filed a complaint, a person manually will see it and has to link it with that particular complaint and close this new complaint. Few days may go in that. It can happen, if you're lucky, it will happen on the same day. But given the volume of complaints being received by Ombudsman, I guess it will take more than a day. So in that case, it is better to do it, and re-registering for same cause of action will not be entertained. It will not be accepted. So once the complaint is assigned to the Ombudsman office, a particular dealing official is given. It will just land in their basket of work. Simultaneously, the regulated entity that the complainant has named in his complaint will also be sent an intimation and a copy of the complaint to respond within 15 days. So the regulated entity will also have to respond and give its written version with all the documents it has in its side to present its case. And irrespective of the documents that are first filed by the regulated entity and the complainant, the Ombudsman has the power, and the dealing official also, based on the SOP put in place, they will know for these type of complaints, these documents have to be received. Say only 4 out of 5 documents have been received either from the complainant side or from the bank side. The dealing official himself will approach you mostly through email. If email is not available, through phone, asking for a specific document. If a document is seen as required, they will reach out to you asking for a specific document. All the more important to give your phone number correctly and to give your email ID correctly. Because if neither of these are correctly available, they may have to go ahead with either a physical delivery of the information requisition, in which case it will take even more time, or if they think, okay, that is just an additional document, it is not 100% necessary, they may choose to process within the documents available, which may not work in your favor sometimes. So any document that is seen as relevant can be called for by the Ombudsman, and if the regulated entity fails to comply with the information requisition without sufficient cause, Ombudsman can draw an inference that the regulated entity does not have any information to furnish in this case, and they can duly proceed, assuming that the documents filed by the complainant is all that is required for this particular cause of action. So confidentiality has to be maintained by the Ombudsman, and they will maintain the confidentiality except as otherwise required by law, or they will share it with the consent of the person who is furnishing such information. So either it should be required by law to disclose a particular information that has been shared under the scheme, or with the consent of the person furnishing such information, or let's say these are two parties to the complaint and they have to know what each other has furnished in that respect. Again, if it is considered necessary to comply with principles of natural justice and fair play, if it is considered really required for this complaint only, that is to be done, the Ombudsman can take a call that it's not necessary in a particular case that whatever has been filed by the bank has to be shared with the complainant or vice versa, and can choose to not share also. The power lies with the Ombudsman to the extent they feel it is required. Again, if they are required to share it before any court, forum or authority, there this confidentiality clause will not attract. Coming to resolution of complaints, the Ombudsman proceedings are not bound by any rules of evidence as a court of law, as we had already discussed. So it's not necessary a court-like procedure has to be. It's not possible that a court-like procedure has to be followed. It's not necessary, it's not mandated, and it is not done also. So either party can be examined and statement can be recorded, that is available. Let's say mediation is called for and both the parties are required to be present, and their statements can be recorded and a party can be examined by the Ombudsman. So a particular bank, say, is not able to furnish, say SMS logs are required and they are not able to furnish within 15 days. They are asking another 20 days to furnish. And based on the number of complaints that has been, seen and examined on a similar matter, Ombudsman is convinced, yes, it will take 45 days, it will take 35 days to get the SMS logs. Can they give additional time to the regulated entity? Yes, they can. So if there is a sufficient cause, the Ombudsman has the power to give additional time to the regulated entity to come back with the required documents sought. So again, why a strict timeline is not possible. So let's say the Ombudsman has given the final deadline. By this particular time, you have to give. but the regulated entity has not given. The Ombudsman can proceed ex parte based on evidence that is available on record till that date. And if an ex parte award is issued, there shall be no right of appeal to the regulated entity in respect of such an award, where it is on account of non-response or non-furnishing of information sought within the stipulated time. Can the complainant go and complain for an ex parte award? Yes. Only the regulated entity is precluded from appealing against an ex parte award. So a conciliation meeting may be called if they are not able to reach to a conclusion just through the facilitation process. There, both the parties will be allowed to represent their views and get a hearing, and then the minutes will be recorded. A final conclusion will be reached towards the end of the conciliation meeting. So either the parties themselves come to an agreement, or the Ombudsman will convince, saying that why don't you do this, why don't you do that, and if still they are not coming to a common ground, the Ombudsman may proceed to give an award saying this has to be done by so and so person in this particular case. So that is a resolution by conciliation or mediation. The complainant is also, it is in the best interest of the complainant to produce the documents called for by the Ombudsman at any stage, because sometimes what happens, the complainant takes so much time to produce a particular document and eventually keeps asking for more and more time. So there, the Ombudsman can give a final deadline and tell, okay, by this time you give, otherwise we'll proceed as if the document does not exist. So let's say in a conciliation meeting, an amicable settlement has been reached. So the fact of the settlement and the terms of the settlement will be recorded and signed by both the parties, and eventually the stipulated time within which the parties have to complete their action points will also be given, and the parties, once the award is issued, the complaint will be closed, but the compliance to the award is still followed up by the Ombudsman office until the logical conclusion is reached. So coming to the award passed by an Ombudsman. So if the Ombudsman passes an award, it will take into account the basic principles of banking law, the instructions, directions, guidelines, say for MSME loans, what are the directions issued, whether those have been followed. And it is in our own interest that if we feel a particular circular or particular direction has not been followed in our case, due to which we have been put in a disadvantageous position, it's in our own interest to point this out in our complaint itself and not wait for a hearing. Sometimes the hearing may not happen. So it's better to include in the complaint itself. And if you feel handicapped by the word limit in the complaint portal, then feel free to write an email or send a physical letter. Because a few days delay in the complaint registration should not hamper you from getting a right decision at the end of the day. So award will carry specific instructions for specific performance on, it could be either party or both parties. And at the end of, once an award has been given, it will also include how much compensation has to be given and whether compensation is found suitable for a particular case or not. And let me also say regarding compensation cases, most cases where there is a financial loss, direct financial loss, the regulated entity is required to make do that financial loss, where there is no fault on behalf of the customer. However, when it comes to consequential loss and mental anguish compensation for mental anguish cases, it is taken. It has to be very, very clear that in that case that has happened and there is a definite consequential loss and there is a definite mental anguish or harassment that has happened. Only then a compensation will be given on that account. For example, let's say there was a complaint where a super senior citizen was going between the branch and the zonal office again and again without getting a resolution. And this was going on for months. And this super senior citizen was already going through another personal tragedy in life. And all that documentation is there, death certificate of the relative, everything is there, and how this person was not able to get the money for which he or she was a nominee. Then there is a clear case of mental anguish. So there a compensation would be given. But will it be exactly what they have asked? That we cannot say, but a compensation most likely is given. Again, it is a discretion. Whether to give or not is a discretion of the ombudsman, but in such cases where a senior citizen or super senior citizen is put to a lot of hassle, compensation is given. And let's say the bank lost your property document. So now you get a certified true copy of your property document only. You don't have the original copy. So there, obviously, the sale rate that you can get with a document is more than the sale rate you can get with a certified true copy. So there is a consequential loss, clearly. So there, some amount of compensation can be expected. So say once the award is issued, so a copy of the award is sent to the complainant and the regulated entity. The complainant has to send to the regulated entity a communication stating they are accepting the award within 30 days. If they don't send this communication within 30 days, the award shall lapse. And once the award lapses, can you come back to the ombudsman again for the same cause of action? No. You either accept or you go for an appeal. So once, say, the regulated entity has received the communication from the complainant saying they have accepted the award, then for them they will have 30 days to confirm compliance to the ombudsman for the actions they were required to do. So if you do not accept the award and 30 days is lapsed, then there is no action required on the part of the regulated entity. So only when the complainant accepts, regulated entity has to act. Of course, the regulated entity can choose to not act and go for an appeal. As much as the complainant can go for an appeal, the regulated entity also can go for an appeal. Now let's quickly go through certain grounds on which complaints are rejected. If it's not in the nature of a complaint, if there is no deficiency in service, the bank has strictly acted according to the terms of the contract. So you may feel that the terms of the contract are unfair, but that is something you should point out and get rectified before you sign the contract. So if your loan term agreement has got something that you are not agreeing, you cannot come and dispute it before the ombudsman later. If there is something that you don't agree, you get the terms changed with the bank before you take the loan, before you sign on the dotted line. Sometimes you get 300, 400 pages of documents requiring a detailed, elaborate evidence to be examined. So those proceedings, such proceedings are not appropriate for adjudication before the ombudsman. So where elaborate documentary and oral evidence is required to be examined, there it will be rejected saying the complaint requires consideration of elaborate documentary and oral evidence, and proceedings before the ombudsman are not appropriate for adjudication of such complaints. So where 300, 400 pages of material running into transaction logs of 5-6 years are going, I think this is not the forum, and if you file before this forum also, they will reject it on this ground. If the compensation is sought beyond the limits given to the ombudsman, that will also be rejected. And when we say complaint not pursued with reasonable diligence, it applies to the complainant's pursuance of a complaint. So what is reasonable diligence? Let's say you filed a complaint, forgot about it. You are coming to the ombudsman after 12 months asking, I had filed a complaint, I have not heard anything about it. It's been 1 year. So you have, that complaint can be closed saying you have not pursued with reasonable diligence. Are you required to give a reminder every 2 or 3 weeks? No. Are you required to give a reminder every month? No. But are you required to just leave it as it is and wait for a resolution for months and years together? No. So reasonable diligence has to be shown in your pursuit of the complaint. Complaint without sufficient cause. Let's say, yes, sir. 1 or 2 months is generally normal, sir. So that's fine. Let's say you don't get within 3 months. So there I think you can send a reminder. Reminder to the same email through which you gave the complaint, or on the portal file a fresh complaint as a reminder. File a fresh complaint on the portal as a reminder to that complaint number which you've already got. 2 months is 1 or 2 months is very early. So let's say beyond 2 months, 2.5 months or 3 months, that you can do. So that shows you are pursuing. Rest assured, this clause is very rarely used. And as I said, like if you waited for 12 months and then you come, very rarely used, because now if it's under the system, if it's in the system, somebody has to deal with your complaint. It's not that, they can choose to sit on the complaint and see whether you're pursuing it or not, and then choose to, okay, this person has not pursued, let's close it. That doesn't happen. But yes, reasonable diligence requires after 2 months, after 3 months, you send a reminder, you are diligently pursuing as to what is happening. Because you see, there is a contact center also, as I said, where you can ask for the status of your complaint, but you may not have a record of that in the system. To ensure that the system captures that you are diligently pursuing the complaint, as I said, send an email to the same ID from where you're filing the complaint, and the crpc@rbi.org.in email ID, and or send another complaint through the CMS portal. And just state that this is a reminder. So there is a record that you have pursued with due really reasonable diligence. So complaint without sufficient cause. So let's say you applied for a credit card. Bank rejected your application for the credit card. You went to Ombudsman. Ombudsman said commercial decision, case closed. Suddenly you have received the credit card the next day. You have got what you wanted. Now you are complaining, saying, why did they issue the credit card? So this could be seen as a complaint without sufficient cause, unless you say, now I don't want the credit card, take it back. If you choose to keep the credit card, but you are simply filing a complaint to take maybe a pot shot at a bank or regulated entity, that is without sufficient cause.
In that case, suppose after filing the complaint, another one thing I got a credit card. Then I have to go on the year and withdraw my what is the solution for me in that case? I want to accept the card. I want the solution to be sorted out. So I have to go and report to RBI that I have received the card. Please close the matter.
Actually, you need not report. Bank itself will report saying we have issued. So it's not necessary that you report. You can withdraw if you want. At any point in time, until the decision is passed, you can withdraw. And that will reflect in the system. But if you don't choose to withdraw, bank will definitely inform RBI saying we have given the credit card. So they will ensure that it is closed, because they are definitely under pressure to close the complaint. So that is something that will happen. So of course, if your resolution has happened after coming to the Ombudsman, that will definitely not fall under sufficient, not without sufficient cause. Yes. At any point in time, before the final decision has been taken, you can withdraw. And it will automatically reflect in the CMS portal, which the employees are using to process the complaints. And then once they find that field populated that the complaint has voluntarily withdrawn on such and such date, let's say the dealing official has passed it on to the Deputy Ombudsman. Deputy Ombudsman has also passed it on to the Ombudsman for decision. It's pending with Ombudsman for decision. The day the Ombudsman is going to give the decision, they are saying that this has been populated, withdrawn via online, so and so date. They will take it as withdrawn. So that is not a problem. Before the closure letter or the closure intimation comes to you, closure intimation could be through an SMS, closure letter may take some more hours to reach you. Before that comes to you, anytime you can withdraw. So let's say no financial loss or damage or inconvenience. So there was no inconvenience, no financial loss, no damage. At least in the previous case, there was some delay in the issuance of the credit card. Let's say that was also not there. Let's say I went to the branch, I wanted to be attended to in the first 10 minutes, I was attended to in 25 minutes. 25 minutes may not be seen as and I'm not a senior citizen also. So it may not be seen as a big inconvenience. So it can be closed under this. So, does the complainant have right of appeal in all cases? Not all cases. In all award cases, yes. In closure cases, in some cases only the complainant has right of appeal. So, what are the closure clauses under which you can appeal? So, if your complaint is closed in terms of the following 4 clauses which I am going to read, then you can appeal as a complainant. So, if I say you have not pursued your complaint with reasonable diligence, it's appealable. If I say you have complained without sufficient cause, it is appealable. If I say your complaint requires consideration of elaborate documentary and oral evidence and proceedings before Ombudsman are not suitable, you can appeal for that clause closure. If I say there was no financial loss or damage or inconvenience, I can appeal saying, how can you say 25 minutes is not important for me? That's possible. Whether the decision will come in my favor is a different question, but can I appeal for that clause of closure? Yes. So, regarding right of appeal for RE, so regulated entity cannot appeal where award has been passed on account of the fact that they have not furnished the required information within the stipulated time. So where there is an ex parte award, regulated entity loses the right to appeal. In all other award cases and the same clauses which I just read out, regulated entity can also appeal. And this appeal has to go within 30 days. And this 30 days will be counted from the date on which the communication of the award or the communication of the rejection of the complaint was received for each person. So the complainant, communication of award or communication of rejection, whenever it reached the complainant 30 days from then. For the entity, it is actually instant. The moment it is closed, instantly the communication is available. So from there itself, it will be 30 days. If you are not able to file within 30 days, you need just 10 more days to file it. Can you make a request for extension? Yes, you can make a request for extension, but it is within the powers of the Ombudsman to decide to give you or not to give you. Maximum up to another 30 days they can give. Either the complainant or the regulated entity can be given additional time up to 30 days. But you have to give a sufficient cause. The regulated entity also has to give a sufficient cause for not making the appeal within the first 30 days. And so appeal is also available through physical letter, email, and this one, complaint portal. Email is a different email. It is aAOS@rbi.org.in. Double A, Ahmedabad, A for Ahmedabad. org.in. Appeal. Yeah. So where the complaint can be given was crpc@rbi.org.in. The appeal should go to aAOS@rbi.org.in. So if you
give a complaint to crpc@rbi.org.
Yes.
Through email.
Yes.
It can be given physically to the RTI office.
Yes. That also can be given. Yes, I would see the scheme says you have to send it to centralized receipt and processing center. But since I am aware staff attached to centralized receipt and processing center are sitting here also, you can send here also. It will be eventually taken up. But the scheme says to give it to Centralized Receipt and Processing Center, which is in Chandigarh. Again, I think the address is available on the website. Editing. Yeah. So this is the address to send physical complaints. So for centers where we are not sure whether there could be somebody attached to this particular center, CRPC center, staff may not be there, it's better to send to this address. It's a Chandigarh address, but this is the address to which physical complaints have to be sent. Yes, and this is also an important address. Let's say the regulated entity against which you have a complaint is not covered under RBI Ombudsman scheme. So you have a list of address of consumer education and protection cells. So if it is not covered under RBI Ombudsman scheme, it is a regulated entity. You have a customer relationship with that entity. You have a complaint. So depending on where this dispute has arisen, the location, you will choose a CEPC office location, Consumer Education and Protection Cell location, and send it to them. Again, email IDs, as I said, in the website itself is available. These are the addresses. This is also available on the same CMS website to which you go for filing a complaint. And here you will find one list which shows entities which are covered under the scheme and one list which shows entities not covered under the scheme. So before filing, you can check. When a regulated entity files an appeal, it has to have a prior sanction of the chairman or the managing director or chief executive officer. In their absence, somebody at the rank of the executive director can sanction that appeal. Only then the appeal can be filed before RBI Ombudsman. So scrutiny and processing of the appeal is done by the Appellate Authority Secretariat. As we discussed, it is done by the Consumer Education and Protection Department. So there will be a team within the department who will be taking appeals as and when they come and putting up the case before the executive director. Whether they will refer to the ombudsman or not depends from case to case. They may talk to the ombudsman who gave the initial decision. They may not talk. It is completely left to them. Whether they want any information from the ombudsman or not, they can choose whether they have to ask or not. Otherwise, all the documents are available online on the portal. So any document that ombudsman is taking cognizance of before giving the decision is available on the portal. It's already uploaded. So even if something is received through physical delivery, it will be scanned and uploaded. So everything is already available on the portal. So that would not be a problem. They will have access to all the documents. So how does the appellate authority deal with the case then? So he will give a reasonable opportunity of being heard to both the parties. And after that, the choices before the appellate authority would be as follows: dismissing the appeal, or he may allow the appeal and set aside the award or order of the ombudsman. He may remand the matter back to the ombudsman for fresh disposal in accordance with some directions which he feels are necessary and proper for disposing the case, or he may modify the ombudsman award or order and pass such directions that may be necessary to give effect to the modified order. Or he may choose to not follow any of these and just pass any other order as it may deem fit. A fresh order is required, it's not a modification. He may not remand back to the ombudsman. He is not allowing also, he is not dismissing also. Something that does not fall under this category can also be done. So that will fall under this particular clause which says pass any other order as it may deem fit. And once an order is passed by the appellate authority, it will have the same effect and power as an award or closure under the rejection clauses that we saw. So if it's going to have the same effect as an award, again, all those acceptance from the complainant and, of course, appeal is not there, but acceptance from the complainant and then subsequent compliance follow-up will all be done. Let's say the complainant or the regulated entity are not satisfied with the resolution provided by the Ombudsman or by the appellate authority. They are definitely free to approach all other forums, all other fora that are available to them under law. So what are the directions for regulated entities under the scheme? So there is an overarching requirement from the regulated entity that they should do whatever is necessary to ensure smooth functioning of the scheme. So they cannot come and say we don't have staff to administer the scheme. They have to do whatever is necessary to ensure the smooth functioning of the banking ombudsman scheme. So if a complaint comes from the portal, they have to allocate somebody to respond to the complaint. A staff has to be assigned for that purpose. And all other requirements under the scheme, the timelines, everything has to be adhered to. Any non-adherence to the provisions under the scheme is taken seriously. So, let's say the regulated entity has not filed the required information within time. Is it the only next thing that can happen is an ex parte award? Actually, procedurally, there is a stage before that. Although the scheme doesn't provide for it, which means this stage can be done away with any time if it is felt necessary to do so. That stage is where an advisory is sent to the regulated entity. So I have basically, let's say the bank has basically given a reason stating that they are not able to file within a particular time. They're constantly asking for extended deadlines. At one point of time, RBI may take a call on this particular date. If you don't give these information, then it will be treated as you have no further information to offer in this case. And then the bank again misses that deadline also. So then RBI can proceed to issue an advisory. It's not an award. It is an advisory saying, say it was a disputed amount, credit that amount to that account. Then if they do come back with the documents that are in favor of the bank's case, then the advisory can be withdrawn. This is a procedural thing which is not detailed out in the scheme, but yes, this is a procedure that can happen. At any point in time, if you do come to know as a complainant that an advisory was issued, you cannot take it to construe as an award. It is not an award. It does not have the effect of an award. So that's about it. And then going to the appointment of principal nodal officer. So every regulated entity has to appoint a principal nodal officer at the head office. So this person has to be at least at the rank of a general manager or any other terminology that corresponds to the rank of a general manager. It could be, say, a vice president, depending on the entity. And then the person is responsible for representing the regulated entity at all levels under the scheme. Of course, in their absence, they can delegate the responsibility to one or more nodal officers under them. So the information furnishing that happens under the scheme on behalf of the regulated entity, the responsibility is actually assigned to the principal nodal officer only. So these officers are also responsible for coordinating data collection as required by RBI from time to time. For example, in November 2022, there was a nationwide intensive awareness program that was done, and all the regulated entities were required to undertake awareness initiatives to spread awareness about the RBI Ombudsman scheme. So there, the progress of the implementation was collated and furnished by the principal nodal officers because it was again spreading across regions. So there again, the first point of contact for RBI tends to be the principal nodal officer. And why this person is important for a complainant or the general public? Because you can approach this person also during your time taken to escalate within the bank. So say the branch level, there has been no resolution. You want to escalate to nodal officer, principal nodal officer, and then come to RBI. You have enough time for that also. So display of details at the place of business. So what are the details that the bank has to show at the display at its place of business? So place of business need not be only branch, wherever any portion of business of the regulated entity is conducted. Even say just one product is being sold at one particular place, which is maybe inside another entity, that also becomes a place of business. So the name and contact details of the principal nodal officer has to be given. Contact details would mean phone number and email ID, along with details of complaint lodging portal of the Ombudsman, and this should be displayed prominently. It should not be in some corner where no customer gets access. So then salient features of the scheme are to be displayed prominently in the offices. Salient, what are the salient features? It is given in the press release that came out with this Ombudsman scheme. It lists out 6 to 7 salient features, and those salient features have to be on the notice board or at a prominent place in the place of business. And it should be, these salient features have to be trilingual, English, Hindi and regional language. The entire scheme you can choose to keep only in English or only in Hindi, or I mean in English and Hindi alone, without attempting a translation at the regional language level. But the salient features have to be trilingual. What are the details that are required to be shown on the website? Again, salient features of the scheme should be shown on the website, along with a copy of the scheme should be on the website, that is the entire scheme document, and contact details of the principal nodal officer, and these have to be always updated. So if it's not updated, it is non-compliance. So coming to the salient features, let's just quickly go through what are those salient features also. Earlier, the complainant has to identify under which jurisdiction his complaint has to go. He has to identify the specific ombudsman to whom his complaint has to go. Now it is not required. You simply file it. It can be handled by any ombudsman across the country. You don't have to do any identification process of finding the jurisdiction. Earlier, criteria was given saying under these services if there is any deficiency, on these accounts if there is any deficiency, you can file a complaint. Now it's a very broad definition. Unless excluded, if it's a deficiency which is not falling under the exclusion list, you can file a complaint. So that way this is much more broad based. And then earlier, the principal nodal officer was not the person responsible, but now assignment of responsibility has been taken to the next higher level. Earlier it was only the nodal officer. Now the responsibility has been taken to the higher level of principal nodal officer. And this particular clause which says the regulated entity loses the right to appeal when it is ex parte award, that is also new and salient feature of this particular scheme. It was not there earlier. A copy of the Banking Ombudsman scheme has to be available at all branches of the regulated entity to be produced to the customer if required for reference. So I can approach any branch and say, I want to see a copy of the Banking Ombudsman scheme or the RBI Integrated Ombudsman scheme. They have to give me a copy for reference. They need not give it for me to carry it home, but I want to refer it inside a branch. They have to give me a copy to refer it. These are all actually checked during branch visits by RBI officials, during incognito visits by RBI officials. When Department of Supervision goes for their regular annual inspection, this is done, at least with 1 or 2 branches, this check is done. And it's mostly, the scheme will either directly be on the notice board or it will be lying with some staff in the branch. But you have to find out with whom it is there. It should be there with some staff. Actually, appointment of internal ombudsman is not covered under the scheme, but it is part of the broader framework laid down for grievance redressal. And So why we have an internal ombudsman? There are certain complaints are required to be vetted by the internal ombudsman also. So his comments are also available in the CMS portal for the dealing officials, for the deputy ombudsman and the ombudsman to see. So sometimes the comments from the internal ombudsman may take more time before the decision is already taken before that. That can also be done, but it's not necessary that the comments have to reach before the decision is taken. However, it is well within the roles assigned to the internal ombudsman to give certain, to give his attention to certain types of complaints, and he has to come up with his comments on those complaints. At any point in time, if the ombudsman chooses to say that you have to give your comment before I take a decision, they have to give, because ideally he should be giving a comment on this before the decision is taken on the complaint. But this is not strictly insisted upon. We will not get into the criteria for appointment of internal ombudsman because it's not related directly to the scheme. And there's a separate master direction. So miscellaneous. So this is basically giving RBI powers to enact provisions so that any difficulty is encountered in the functioning of the scheme, they can bring provisions to ease it out. So that is a miscellaneous provision under the scheme. And of course, it should not be consistent with the powers based on which the scheme itself is given. So all those acts come into play, and it should not be inconsistent with the basic core of the scheme. And all the existing schemes that were there, the three schemes, the digital ombudsman scheme and the NBFC ombudsman scheme and the banking ombudsman scheme 2006 were repealed when the scheme was introduced. Of course, complaints which were pending already were taken to their logical end under those respective schemes. So we will quickly see 3 videos. Before we see those videos, I'll just mention which are the essential details that you require before getting ready for filing a complaint. So details of the regulated entity, the branch or office name, your relationship number or account number with the regulated entity, your personal details, name, age, gender, full address, contact number, email, details of the grievance with respective transaction details if a particular transaction is a cause of action, and then RE complaint details, the date on which you made the representation to the complaint, made the representation to the regulated entity, whether did you send a reminder to the regulated entity, although this is not compulsory, even if you have not sent a reminder to the regulated entity, it is just asking whether did you send or not. It is not 100% required that you should have sent. Any reply was received from the regulated entity within 30 days. So if you're filing within 30 days, if you have not received a reply, state the fact. If you have received a reply, file a copy of that reply also along with your complaint. What is the specific relief sought from the ombudsman? A lot of times, there may be 2 or 3 things that the customer needs, customer needs from the bank. But in the complaint, he would have highlighted only one complaint and he would have, in a passing reference, it may not be even clear whether he finds it as a deficiency in service, but he wants a resolution there, but he's not sought it as a relief, then it may get missed out. So specifically tell what is the relief that you seek under the scheme. There is a declaration that says whatever I'm stating here is true to the best of my knowledge. One declaration will be there. When you go through the portal, it is automatically captured. And when you give a physical, again, this is where the physical letter has to be in the format given by the scheme. So all these are duly captured. The letter of authorization, there is a format within the complaint form. The declaration, there is a format within the complaint form. So if you file it in that format, if you find it very restrictive in space, just use the format, put it in a separate Word file and send a detailed complaint. But it is better to adhere to the format even when you are giving a physical complaint rather than a free flow way of writing. So the any supporting records that you might have. Like for example, say I had certain reservations about the terms of agreement in the law, and they said, okay, we will get these few terms changed. I have an email correspondence with them where they tell me, okay, this particular clause for your case alone will be read so and so. So the chronology shows I had a loan agreement given to me. I raised an issue with regard to a particular clause, and then he has said, for you we are making an exception, and for this particular clause will be read it in a different manner, so and so way. Subsequently, they told me, okay, we will revise the loan agreement also and give it to you, send it to you. That never happened. Immediately a dispute has arisen with respect to that clause. They are telling our loan agreement doesn't show that clause. But I have the email correspondence that shows for you they have made a specific case. So that email correspondence becomes very relevant. So such supporting documents should also go through along with your complaint. Let's quickly see three videos, and I think we'll be good to close with that. There is no audio, it's just the video. This is the CMS portal way of filing a complaint. Actually, it provides only English and Hindi, although the drop down will show a lot more languages. However, you can copy paste any language onto the details of the complaint. So where it is not, where the facts of the complaint, description of the complaint is to be given, you can type it out in any language and copy paste it. It will be captured in CMS. So again, it is asking for area of operation of BO. If you know, you can give. If you don't know, you can simply choose whatever you think is the most suitable and leave it. It's not necessary to accurately identify it under the new scheme. And certain questions such as whether the complaint pertains to a credit card or to a wallet is being asked in order to classify the complaint correctly, to accordingly send it to the correct entity, and also to ensure proper data analysis. So even if they are not compulsory, I would suggest give the correct data so that the system captures wholesome data on complaints.
Is this complaint given to the bank initially? Is it compulsory?
Yes. Otherwise, it will not be taken under the Ombudsman scheme. It has to be first. Yes, sir. Yes. 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 Okay. 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 Actually, you are supposed to give the complaint against your bank also. I mean, the complaint against your bank primarily, mention the name of the other bank. No. In the facts of the complaint, you will point out the other bank. Facts of the complaint, there is a place where you will have to give description of the complaint. There you will point out the other bank. Saying my RTGS was done from this particular bank to this particular bank. Give your RTGS form details where you have correctly given the details. Give the correct account number and all. So it is visible from your form that you have given it correctly. your bank will reply saying, we did it correctly, they did not do it correctly. But since you have already named the bank, this complaint will be marked a copy to that bank also once it's in the system. That bank will be asked to respond. If that bank says we will recover and give, they will say you recover when you want to recover, but you first give.
But that bank is where this bank who has sent a letter, they came pressurized and to give the money immediately.
See, the bank will pursue because the bank is not at fault. It wants to retain the customer. So it will pursue with the beneficiary bank to ensure the correction happens. But the power of an ombudsman is way more. When an ombudsman office tells that bank, you recover when you are able to recover, but ensure that the correct beneficiary gets the amount right now. Because the mistake is on your side, they will do it irrespective of whether they are able to recover or not within the time.
What is the time limit? They say we will recover and we will take a lot of time.
No, you don't have to wait for them to recover only.
Because there is already one complaint is pending now. No action is taken.
No action is taken by whom?
The person has not received the money.
Okay. The complaint is pending with the ombudsman?
They say, now we can go here and give a complaint to RBI ombudsman.
Yes. Say if I have given the correct beneficiary account number. Say if I have done a mistake, then I cannot. If I have done a mistake, I cannot.
Does the bank who issued the RTGS has to verify the name and account number both, or only one is enough?
Account number is enough, sir. Yes, account number has to be correct.
But they don't verify the name.
Need not.
But if you see the portals of the banks, where they say is, if a RTGS has gone with both the things, name and account number, the receiving bank has to verify both and then give a credit. If one of the thing is not matching, they have to go and back, get it confirmed that the bank will send the RTGS.
So I am saying based on the transactions I have seen. If the mistake has been on the sender's side where the account number is given wrongly, then they will attempt for recovery and based on recovery they will give. If I have given the correct account number, the bank only has done the mistake, irrespective of whether they are able to recover or not, they have to give it to the correct beneficiary.
But the bank who received the RTGS doesn't verify both the things or only one.
Sometimes it does not and it need not.
But I went to the circular where it says the receiving bank who received the RTGS has to verify both the things and then give a credit. If one of the things is not matching, they have to get it confirmed from the bank who has sent the RTGS.
And they have not confirmed from the bank.
They have not sent back the bank
Okay, if they have definitely. Okay. Okay.
who has sent the RTGS. If they have not sent back, they have not had a confirmation from that one of the thing is not matching. Please confirm.
Okay. Okay. So let us look at two possibilities here. Suppose the bank had a communication with your bank and asked, say this is not matching. And this is not matching. And your bank said, go ahead. Then the circular that you have said has been fulfilled. If the bank has not at all communicated, then there's a violation of the circular. Then you are on the right side. So you raise specifically on this ground that the bank did not check back with my bank. Yes, there was a mistake, but the bank should have checked as per the circular, which it did not. So they have to come back and prove that they checked and the bank gave a go ahead. Or if they are not able to prove, they will get the correct beneficiary account credited.
Because the bank who has sent RTGS is telling me they have to confirm with me. If I don't confirm, it is their duty to revert back the money to my account.
Yes.
Not credit the party account. So they have not given a confirmation to us and they have credited to the party account,
Okay.
which other party accepts
Okay.
that we have credited to the wrong account and we will recover the money and give it to you.
Yeah. So if there is a clear violation of the RTGS rules, on that ground you can although there was a mistake on the complainant side, you can still pursue saying the required procedure was not followed, and therefore the bank is required to credit to the correct beneficiary account. Because there is a deficiency in the service of the bank if they have not followed a due procedure.
Now, one more doubt in this. It says you can go here only after 30 days from raising the complaint with the bank.
Yes.
Now, I cannot wait for 30 days because it is a matter where the bank has accepted that it is received service.
You have got the reply. No, you can, yeah, you can go immediately. Once the reply is received, you can go. 30 days is where you have not got reply.
I got a reply by email. That's enough.
Yes. As long as it's a reply, it should not be just an acknowledgement of a complaint. I'm sure you've got a reply and not an acknowledgement of a complaint. So, no, that is fine. But acknowledgement cannot be treated as a reply to immediately go to RBI Ombudsman. That's what I'm trying to say. So, if you got a reply, that is good enough. You don't have to wait for the logical end to happen. No, from the time you got the reply, it's 1 year. So, if you got a reply, you have yet to exhaust your 1 year time period, go to RBI immediately with the reply. And as I said, state what has happened, admit, okay, there was a mistake on the account side, but the bank, if they had followed the due procedure, they would have found this out. Based on the information I have got from my bank, they have not checked back. It's possible that this bank gave a go-ahead also. We don't know. It's possible that the sender bank gave a go-ahead also after checking. We don't know. That Ombudsman officer will find out. That's what I'm saying. Yes. Yes. Yes.
But other bank also, see, by email, this bank says we have received an email stating that we have given a credit to the wrong account. We are in the process of recovering that money.
Yes.
We'll come back to you.
Yes.
That is a reply.
That is a reply good enough for you to go to the Ombudsman saying that the bank has not followed due process. I am made to suffer. My beneficiary has not got the money. My intended beneficiary has not got the money. Please ensure that the money is credited to the intended beneficiary. Recovery is up to them. How they do it, when they do it. If they have not followed due procedure, the beneficiary has to be corrected and they have to give it to the correct account. If they have followed a due procedure and it amounts to just the flaw in the form where the account number was filled with a mistake, then we are at a loss. But otherwise, you can ask the bank to rectify.
No. See, the form, name and account number is written. The RTGS, the bank is receiving RTGS.
Yes. Yes, if that is the requirement and if he has not done it, yes, he will be at fault.
If you go through the software what the bank has got, the bank sends RTGS with both the details, beneficiary's name and the account number. Receiving bank has to verify both the things and confirm. The software also says if one thing is not matching, you have to get a confirmation from the bank who sends the RTGS.
See, software saying is one thing. If it's a circular requirement, if it's a direction, if it's a guideline, if it's a rule, it has to be followed.
But is there any circular on this matter?
We will have to check the RTGS circulars. I am not fully familiar with all the contents of the RTGS circular. So we will have to check with this. I would urge you to go through it. And if you find that both have to be checked as part of due process, you can. Even if you are not able to find the circular, if you feel that because the software prompts there would be a requirement, just that you're not able to locate the circular, good enough, you stake claim on this basis saying that although they are supposed to check, they have not checked and it has been wrongly credited. If they are not required to check, it will come as a reply saying there was no deficiency in service. If they are required to check and they have faltered, the money will be credited to the intended beneficiary. You file a complaint. Let RBI examine and see who was at fault. If the complainant and the bank were also at fault, if the bank is found to be at fault, they will be required to rectify. They cannot say because there was a mistake on the complainant also, you cannot ask us to rectify our flaw. So if both are at fault, bank will also be required to rectify their fault. So you give a complaint, even if you're not able to locate a circular or rule, stating that they have not checked both. If both are not required to be checked, RBI will come back to you saying there was no deficiency in service. But you file the complaint, you have got a reply, you're not satisfied with the reply, you are a customer, the intended beneficiary has not got the money, you have every ground for filing the complaint.
If RBI says there is no discrepancy in service,
Then it means it's not a requirement to check both.
my knowledge,
That's what you write the complaint, let them examine and find out whether there was a flaw or not. I would urge you to write the complaint. Based on whatever documents you have already got a reply. Yeah, you file with that. You file with that and you also say. That's generally because there is a flaw on our side also, no? So they will. And you also record any consequential loss. That's up to you. But you file the complaint. File the complaint. You have exhausted all the options before going to the Ombudsman. Whatever is required by the Ombudsman to be exhausted, you have exhausted those grounds. So now you have to go to the Ombudsman. Go to the Ombudsman and then it will become clear to you whether that is required or not. You very clearly state that in your view, these have to be checked and this should be returned, but it has not been done so. You need not quote the circular also. Let them examine with all the directions and circulars, rules, and they will tell you whether it was okay or not okay. Because there are a lot of procedural technicalities that may change and we may not be 100% updated with the press releases that are coming from different entities. So we do not know whether it's okay or not okay. So give it a shot, give a complaint. Don't wait, give the complaint. So yeah, as we proceed with the video, the date on which you have given the complaint, a copy of the complaint is better to be attached with this, because say if you give a date and it turns out the bank comes and says no, the person did not come before to us and it is just 3-4 days since your date of complaint, the complaint will be closed as a first resort complaint. So wherever these categories are required to be given, grounds are required to be given, to the extent you find the most suitable option, you choose it. It's okay if it is wrong. Sure, sir, sure. So you will give the complainant details and you will also give the authorized representative details. The word used here is nominee, but that is referring to the authorized representative. It will come shortly. These are again required to be captured to know what rules would be applicable. If you're a government company, what rules could be applicable? If you're an MSME, what rules could be applicable? Many times people by mistake choose a similar named regulated entity. So that will result in the wrong regulated entity be marked. The complaint will be sent to the wrong regulated entity. Say, for example, you have a problem with SBI cards, but you've given the complaint against SBI Bank. But your account is actually with SBI cards. So your complaint will go to SBI Bank. They will come back saying it's not an account with us. Then the dealing official will mark it to the SBI cards nodal officer. Time is lost in the process. So it's important to identify the correct regulated entity. That's not a compulsory field to give the ATM credit card or debit card number. You can choose to not give. Just ensure that the compensation sought does not exceed the limit, because otherwise you are paving way for rejection of your complaint. So this is where you can fill the details of the other regulated, facts of the complaint, other regulated entity. Even if there are more than 2 entities, you can say, like for example, sometimes I do a transaction, a digital transaction, there's a system provider, Google Pay was involved, for example, and there is a beneficiary bank, there is my bank. So I will say, okay, I used the system provided by Google Pay. I used my bank account to send money to that bank account. So everything I will say. It's to facilitate the Ombudsman office to deal with all the related parties, although Google Pay may not be the person at fault here. So they will deal with the related parties and come to a conclusion. So nomination details will be authorized representative details. As of now, there is no requirement that if you are filling these details, you have to give a document showing proof of authorization, but it is better to give it. Because it is understood to be the same in official parlance. Inside RBI, it is understood to be same. So at least for this purpose. It's basically if I'm not able to reach the complainant, this is the person I will reach out to as a dealing official. So it's better to have the proof of authorizing a person to be an authorized representative in writing. So you can take the physical form that is there. Although there is a declaration here, I think again it is only a matter of time, because what is the guarantee? The complainant is only filing the complaint. I can file with my mother's name as a complainant and my name as authorized representative without my mother actually authorizing me. So as of now, this is enough, but at any point in time, they may require. So to have a very clear case on your side, use the authorized representative declaration form in the complaint form physically, scan it, get it signed properly by the complainant, scan it and upload it along with this. Again, of course, it will require an OTP while filing the complaint, but there also, what is the guarantee that the number I'm giving is my mother's number when I'm claiming to be her authorized representative? 2 numbers could be mine. So I can give my one number as my mother's number, telling that she is a complainant, claiming myself to be the authorized representative. That possible flaw is there in the system. To keep it clear from our side, it's better to file with the authorization letter. These are very short videos, just how to track your complaint. Of course, you can call the contact center, the 14448 number. You can call the contact center and find out what is the status of your complaint. You can also see over here, but it is only a broad status. You may not know exactly, like for example, if the bank has replied, you may not know what the bank has replied. But it's a broad status, whether it is lying with the bank or lying with RBI or it is in process or decision has been given. So if decision is given, you should have got the closure letter. If you have not got, ask for it. So these are broad stages that will show where your complaint is lying. Contact center will have 10 regional languages, English. So a person who is not well versed with English or Hindi can also call. It's not available on Saturdays and Sundays. It's available during weekdays. 8 a.m. to 10 p.m. How to file an appeal. The screen looks pretty much like the track of your complaint. Or at one point of time, it will just switch to submission of an appeal. But this is how the navigation actually takes place. So once you file an appeal in the system, automatically it gets reflected against your complaint number across the CMS portal that is inside RBI. Anybody and everybody will know that you have filed an appeal. Although only the department that is going to process the appeal will get into the details, but everybody will know, okay, this complaint has gone to an appeal. So that also you can call the contact center and find out whether your appeal is reflecting in the system or not. So any additional documents you want to upload, also you can upload. Definitely upload your closure letter in your appeal so that it becomes clear under which clause it was closed. Of course, if it is closed under a non-appealable clause, it will not lead you to the screen only because the system knows under which clause it was closed. Also, why that email aaos@rba.org.in becomes important is, let's say if 30 days have crossed and the system online is not allowing you to file, but you have sufficient cause for not filing an appeal within 30 days, you need extra time. The best way is to approach asking for time through that email. Although I would say it is better to ask before the first 30 days lapses on the 29th or the 30th day itself, but even if you miss it, approach through the email even if your system is not allowing you to file an appeal. Any questions? Okay. Thank you. Have a good day.